Good evening, everyone. My name is Tanika Nicholas, and I'm the strategist for the Justice Reform Partnership. And I just want to thank all of you for joining us this evening for our Talk Justice Tuesday. And tonight serves as our final Talk Justice Tuesday that we're going to talk about the legislative session. Not our final, but just about the session itself. And it's been a long 40 days, but even longer for our experts and panelists who's going to share some updates in how the session ended, where some of the bills we were following, our priorities, and what we're going to be looking forward to coming up in 2027. But before we get started, I always like to give a little background about our Talk Justice Tuesdays and, what is that about and why we do our Talk Justice Tuesdays. I see some of you on the call are some of our normal folks, and I appreciate you coming in this evening. But, you know, our monthly series that we now do year round is that educational piece that we need for our for the community, for the folks on this call and the people that's not on the call, for you to share out the things you've learned and to kind of help break down some of these complex policy issues that perhaps that you're going to hear about tonight, that some of these bills and what does that mean for your community. Also, one of the things that it does is that it also gives folks in the justice impacted community a voice to be heard and a space for us to strategize. So that's what our Talk Justice Tuesday does, and we do it second Tuesday of the month, and we're going to continue to do our topics. Look out on our website for other topics that we're going to host as well. But tonight, we're going to talk about, what's next.
Hey everybody, it's good to be with you tonight. My name is Isabel Otero. I am the Georgia Policy Director for the Southern Poverty Law Center. We are coming out of what seemed like a kind of a strange legislative session for some of us, who are used to fighting a lot more bills than what ended up sort of moving forward, in some ways. And we wanted to give you some context for why that was. And this is the second year of Georgia's biennial legislative session. So our legislative sessions last 2 years. We also have every single seat in the state legislature, so the state house and the state senate, are all up for re-election this year. So it becomes kind of a silly season, right? They all want to get something for their campaign. They all want a clip of something. They want to have some sort of fight in order to get the kind of views and momentum that they need for their campaigns. A lot of our usual suspects at the Capital are also members who are running for higher office of some sort. So lieutenant governor, secretary of state, attorney general, governor, so that shaped a lot of what they wanted to focus on and some of the negotiations and fights that were happening behind the scenes. And so, for some of the big sort of priorities did not fall under criminal justice reform for the most part. It was things like property tax reform, right? And trying to end property taxes for most homes by 2036, I think. And that would have caused all manner of problems, especially for public schools and all kinds of things. So those of us who have education on our list, we were fighting that bill. Um, there were also some other pieces around healthcare and access, around trying to expand Medicare finally, or Medicaid finally, and literacy issues. And then on top of all of that, there was a big push from the federal government um, to sort of shift a lot of costs to the states. And so if you remember back in the fall, there was a very large package of legislation that was passed at the federal level that shifted costs like SNAP, dollars that needed now to be produced by the state instead of the federal government, or things like the SAVE Act and things that had to do with elections and identification and being able to vote early or whatever other pieces. So on those issues, they were fighting those kind of uh, having those fights. And so those of us, again, who had those issues on our list were fighting those fights, but we, on the criminal justice end, did not have the same, it was not the same as it usually is. And it doesn't mean that, nothing is fixed. It just means that the politics this year made it so that some of the big ticket items were not as much criminal justice reform related as they were on some of these other issues. And so it means that, some of this we expect to come back. So some of the bills that we'll talk to you about, they didn't pass, which is great. And it shows that criminal justice reform from what did pass and what didn't pass is possible in Georgia. But we can expect a lot of these fights to continue because they're not done. A lot of these things are things that we've seen over the years. They're sort of patterns and themes that we'll talk about today that will show you that it's not really over. It was just an odd year for the criminal legal system to and the bills that it came. But just because the politics was rearranged doesn't mean we get to sort of like walk away and just call it a win and not be ready for the next year, and the next time that some of these things come up. And so with that, I will pass it over to Wade and GJP to talk about some of the bills that did pass, that were good bills that passed, and some of the reforms that we can look forward to.
Thanks, Isabel. Hi, everyone. Good to be with you. I'm Wade Askham, a policy consultant for Georgia Justice Project. And so I'm going to run through some good things that happened. There were all three of GJP's priority bills this year passed. And so they are on to the way to the governor's desk to hopefully be signed into law. One of them in a bit of a modified form, which I'll touch on. And then one other bill that I'll also kind of briefly touch on. So first, HB 162, if you've seen us at Justice Day or at other forums, we've talked about kind of the First Offender Act modernization legislation that we've been working on for a couple of years now. So what that bill would do if the governor does sign it into law is that, first of all, for all people who receive a First Offender Act sentence moving forward, at the time of sentencing, their case record would be under seal. And so it would not be generally available to the public. Now, there are exceptions to that. So, Department of Community Supervision, for instance, will be able to see while someone is on probation, if that is part of their sentence, which is very, very common for First Offender Act, they'll be able to see the case record. So there's some sort of, basic system actor get access, the people who need access during the pendency of that sentence. And then also the same exceptions for sealing generally that already exist under the law still exist. So for instance, if there is, if I want to work in elder care and it's an elder abuse case, they will have a way to access that case that is existing law under existing sealing law as is for certain sensitive populations for very specific histories that are related to that specific sort of vulnerable population that the individual would be working with. But again, that's not a change from current law. So that is very exciting. There are 40,000 people currently in the state of Georgia currently on a First Offender Act sentence. So it is not a small population of people moving forward who will be impacted. Now, for everyone who is currently under a First Offender Act sentence or who has previously completed one but has not had their case fully sealed, unfortunately, there is not an automatic requirement that those all overnight get sealed. Frankly, technologically, we're just not quite there yet as a state. What the bill does do for people who are currently under sentence or who have already completed a sentence is if they go ask for sealing, and as long as they are currently under sentence, if they haven't had a revocation, revocation with an actual conviction imposed, court has to seal it. Same for people who've been successfully discharged, which about 97% of people who are given a First Offender Act sentence end up with a successful discharge. Everyone in that situation, you give a piece of paper to you hand a petition to the court to say, I was successfully discharged, seal my case now. You don't need to argue. It is just mandatory. The court has to do it. No questions asked. It is now black and white. So we hope to do a lot of outreach around that, spread the word, because we know there are a lot, and we know this because a ton of GJP's clients have successfully completed a First Offender Act sentence and then think that the record is limited to the public, and then they find out years later, oh, this actually wasn't sealed, and they come back to us for help with that. And so we want to do a lot of outreach to folks who are impacted to make sure, again, submit that petition. Court will have to do it as long as this is signed into law starting on July 1st of this year. Second is HB 535. HB 535, that is a bill that essentially fixes a Court of Appeals decision from a couple of years ago. It was called Kellum v. State, which what that decision did is it interrupted how time served is calculated if someone is sitting in jail waiting for resolution of a probation revocation hearing. So in simple terms, generally speaking, if I am sitting in jail waiting for a case to resolve, let's say I'm sitting in jail for 6 months waiting for a case to resolve, and then the court decides to sentence me to 1 year of incarceration, I get 6 months that count towards that 1 year of incarceration. I have 6 months to go. This Court of Appeals decision from a couple of years ago said, actually, if you were sitting specifically waiting for a probation revocation hearing, those 6 months you spent sitting in jail doesn't count. You got to serve the whole year. So we got that fixed. Time served counts as time served again, as long as this is signed into law. Again, that would be effective July 1st. So we'll be wanting to do a lot of outreach to, again, directly impacted people, especially folks on probation, that if they hopefully will never be in that situation, but if they are, that they'll know their rights, as well as defense attorneys, judges. Department of Community Supervision was very, very aware of the bill. So they'll be able to do proper calculations, hopefully moving forward, and GDC as well. Next on the list is SB 207. This was our long-term, it's been 4 years that we've been trying to achieve occupational licensing reform in the state of Georgia. So we have been trying for a long time to, really the story goes back more than 4 years, but in terms of this bill, it has been introduced for 4 consecutive years, trying to change the way that boards and agencies across the state, can consider a conviction or arrest record when someone is applying for an occupational license. So when I say occupational license, what I mean is if I have to apply to the state to get a license or some kind of clearance to work in a certain field, so I'm an attorney, I have to go to the state bar. If I'm a doctor, I have to go to the Composite Medical Board. If I want to be a fingernail technician, I need to go to the appropriate state board agency. If I want to cut hair, I need to get a barber's license, and on and on and on and on. There's about 50 boards like this, representing about 1 in every 6 jobs in the state requires some kind of license clearance, including 1 out of every 4 of the highest demand jobs. We wanted to add transparency, some basic due process, and some guidance really for boards and agencies in how a past arrest or conviction record can be considered. So I will skip all the war stories for the last 4 years and tell you about what did pass, because it wasn't exactly the form that we followed it. Some changes did happen, but for more than 40 boards in the state, we will now have, I think the number one thing to emphasize is what we've been calling the pre-clearance process. What that is a way, the most common licensing related question that GJP gets, and back when I was a real attorney practicing and representing folks, most common question I would get at a legal aid organization in another state was, I want to be a nurse. I want to be name the occupation. Will I be able to get a license in that occupation? And the answer has always been, maybe. We don't have a crystal ball. We can't tell you with certainty. And for a lot of people who may have very likely been able to get through the process, they couldn't invest in their education and training off of a maybe. They needed clarity. I know I certainly would. And so what this bill does, it will now allow people for the first time to go to a board and say, hey, before I go to school for this, before I invest in training in this, whatever it is, here's my record. Tell me just as to the record, am I able to go forward and get a binding decision that says yes or no, but hopefully yes, you are good to move forward. That arrest or conviction record is not a problem for us. Go with confidence. As long as you don't, of course, if someone gets arrested again, they would redo the evaluation. But as long as that doesn't change, you have a binding decision to move forward with confidence. That responds to the by far most common question that we get from folks who are interested in license fields. There are also a number of due process provisions in there, like basic stuff that was not guaranteed under the law, like the right to a hearing, the right to bring witnesses, the right to actually have a written, if you're denied, get an actual written decision from the boards that explains why you're being denied, be able to access an administrative appeal, a bunch of just basic protections that we didn't have until hopefully this gets signed into law, and we can say we have them as of July for more than 40 boards. There are also some limitations on specifically older misdemeanors. A lot of misdemeanors that are 5 years or more, we're just going to say we don't need to look at it. There's also a lot of direction to the boards to say we only want you to focus on offenses that are related to the profession. So if I want to be a pharmacist and yesterday I was caught selling prescription drugs, then the pharmacy board is going to look at that. If I want to be a pharmacist and when I was, 19, I got, arrested for underage drinking, that has nothing to do with my ability to be a pharmacist. So actually look at, is there a relation between this arrest or conviction record and the actual profession that you're licensing? Now, there were, at the very end of this whole process, I've said multiple times that this whole structure exists for more than 40 boards in Georgia. There are 5 boards that were cut out of the bill. Those are the Composite Medical Board, Pharmacy, Dentistry, Professional Standards Commissions. They do teachers, educators, and funeral directors. So those don't get the predetermination process or those protections I've talked about. Every other board is covered. So if you want more on that, if you have specific questions about specific boards, reach out to GJP. But I did want to flag that. And the last thing that I want to flag out, which is an unfortunate flag, is for 4 years, there were also some record restriction provisions that were part of this bill. And those, the House decided to cut those out in the final version. We weren't really a part of that. And so that did happen. And so GJP will continue to fight for expanding record restriction in Georgia, as it always has. But I did want to flag that because I know while publicly SB 207 has very much been about occupational licensing, we know of a number of people who are really following it for the record restriction elements of it. And I'm very sorry to report that those did not receive passage. So those are the 3 GJP bills that did move forward and are now again waiting for the governor to sign to hopefully become law. Each of them we think is a massive, massive step forward for the state in their own way. Last bill that I'll just very briefly touch on is HB 519. Folks might know that there is a federal work opportunity tax credit saying if employers hire from certain different populations of workers, that employer is eligible for a tax credit. That tax credit will now essentially be mirrored in state law for up to $500 per year per employee. I highlight it because there are lots of sort of categories or backgrounds of workers that are impacted, but included in them are folks with felony records who are within 1 year of release from prison. So that tax credit is an additional incentive for employers should they feel like they need any incentive in the first place. But wanted to touch on that as well. And so I will now turn things over to Maisie Lynn.
Hi, thanks, Wade. I feel like I want to just double down and say how wonderful it is that you guys were successful on those bills. I know it was not an a quick or easy lift on any of them. And definitely on the McKellum bill, the Gactyl community is really excited. I mean, we're excited about all of them, but that comes on the heels of some legislation that we got passed a few years back about pretrial credit for time served. And so anytime we can get that to work well, we really appreciate it. So thanks so much again for all you've done in those spaces. Um, HB 1131. This was not a bill that we expected or that Gactyl, put through, but it was brought by Representative Sue Hong out of the Cobb County area. She does do some defense work in her legal practice, and this modifies what kind of notice is required if someone wants to go to the courthouse and take a warrant out on someone else. There are some exceptions already in the law about when these types of warrants can be taken and what the rules are about them. This does not apply when, say, a police officer is approaching the court about a warrant, and or for instance, if there's some kind of continuing threat of someone's safety or well-being, um, or if the person is already in custody of law enforcement. There are some, or if they're a fugitive, like I said, there are some exceptions here, but this is the kind of situation where, let's say something happens between two people, even if the police are called, but they decide not to arrest anyone, one of the people wants to go to court and try to take out a warrant anyway. They have that right to do that. But what Representative Hong has done with this bill is require that the person against whom the warrant is sought gets actual personal service of that warrant application. Today, the law allows for any means available as the mechanism for letting someone know, hey, let's say your neighbor wants to take a warrant out on you, they can arguably send it to you by mail. And whether not you actually get notice that your neighbor is trying to take a warrant out on you is of no consequence at the moment, which is what she is curing for. So in her bill, Representative Hong is requiring now that the person who is the warrant is being sought for, who is being threatened with potential arrest, get personal service of that application for the warrant so that they are fully aware not only that the warrant is being sought, but when the hearing is going to be held so that they can come and state their own case if they would like to the court to try to prevent that warrant from issuing. So, like I said, not something that we were directly a part of, but certainly something we're really glad to see happen, because you can all imagine how difficult that must be if someone suddenly realizes a warrant's been taken out against them when they are, arrested in a public space or at the side of a traffic stop or something like that. I'm going to pass the mic over to Isabel.
So I'm starting the section of this where these were good bills, but they didn't quite make it to the finish line, right? So these are bills that have a lot of support behind them, but we ran out of time. So one of them is House Bill 1061, which is the Georgia Raise the Age bill. It would stop the automatic treatment of most 17-year-olds to be tried as adults in the criminal legal system. This the story around this bill is very complicated, but essentially it started out as shifting most 17-year-olds out of the into the juvenile justice system, and it ended up being a slightly different thing, which is that everybody in Georgia politics seems to understand there's real bipartisan recognition that Georgia is out of step. There's less bipartisan recognition on how do you fund how to do this? How do you actually like make a process for this to happen? What is the court capacity? What's the detention space? Like staffing? There is a lot of questions that were not able to be answered immediately. So what they did was instead of just passing the bill without all of this funding and resourcing behind it, they said we're going to actually pass a raise the age bill study committee, essentially. They were going to create a committee, a blue ribbon study committee that would have studied the issue, figured out how to get Georgia through that transition, and then propose that bill. And we've seen these blue ribbon study committees in the past. The most recent one was last year around the election regarding the QR codes on ballots that they have eliminated. And so they went around the state. It's a study committee that gets funded to go around the state in different parts of the state, hear from constituents, from experts, get presentations about the issue, and then at the end they propose a solution to the problem that they've heard about all year. And so it would have at least moved us in the right direction. It wasn't going to be a complete raise the age bill by the time it got out of the House, but it did get out of the House unanimously. It did pass out of Senate committee. It just did not make it out of the Senate. And in part, like I said at the beginning, the Senate has a lot of people running for other things, and this was not a major priority for them. And so they did not prioritize it by then. And so what I would encourage people to do is if this is something that you care about in particular or your organization cares about in particular, I would say that outside of session, you should make sure that you are talking to legislators, to candidates, to people who need to be not just studying this issue, but actually raising the age of criminal conviction for kids. And say that very clearly and make sure that we are holding people accountable in the off session time so that by the time they come back around, they don't just have to hide behind, well, this is what we did last year. They can say, I've actually heard from a lot of people. We don't just need to study it. We're ready to go. We should fund it we should fund it. We should staff it. We should do all the things we need to do to actually get these kids where they need to be. And so, like, I think it's important for us to know that it's a win in that it's moving, right? It's an issue that's been moving for years, and this is the furthest it's gotten, I think, in some bipartisan way. And it is a bipartisan issue, which is a good thing. We can see that people are recognizing that we're out of step. We just haven't been able to make it a high enough priority. And so I do think that with public pressure, with a lot of conversations with legislators and candidates, we can get this moving again. It will be reintroduced, and we hope that the coalition gets behind it and can move it forward next session at the start of the next session. So then other bills are Maisie Lynn again for a couple of other bills that also were good but did not pass.
Yeah, thanks, Isabel. I will add one other comment just from shenanigans, if you will. I don't even know. Maybe it's not shenanigans, but sometimes I tend to be cynical enough to think that most things are when they go in a sideways way. But although this was not deemed a study committee, it's very study committee-like. And none of the study committees that were proposed in House resolutions this year became law or created by the resolutions. And so, with the commentary being that there will be established at some point some blue ribbon commissions that will attend to the issues in similar fashion to study committees. We don't know when those are going to be created. There are some issues on the table that are of interest to our community in this space. But my guess is we're just going to have to get past some of the election stuff that's happening right now before they want to turn their attention to creating those bodies. And so whether or not this is going to fall into that category remains to be seen, but it certainly could. That raise the age could potentially fall into that category, but we'll see. So one of the good bills that didn't pass is House Bill 460. We've been calling this the Burns fix. The Burns case came down not long ago, and it went through the Court of Appeals first and then to the Georgia Supreme Court. And ultimately, and the decisions were that it is no longer privileged for a lawyer to talk to their client if their client is living in a carceral facility in our state. This is not limited to criminal defense lawyers or criminal, or I mean, I guess that's some people that have criminal defense clients, but it's any lawyer. So if you happen to be someone that was in a car accident and also got arrested for some reason as a result of that accident or, close in time, and you have to live in a jail for some period of time, your conversations with your automobile accident lawyer are no longer privileged. This bill was carried by Esther Panich, who is a Democrat House member and also, just in all transparency, a GACTL member. And I know some inside baseball here, and that there were some attempts for this bill to be used as a vehicle for some really harmful um, criminal legal bills that also did not end up getting through. And so, in many ways, the Burns fix was a sacrifice to try to prevent some of the really bad criminal legal bills that kept trying to be added to it from getting on. So, we're very hopeful and expect that this bill will get picked up again next year. It is not controversial. Most everyone that hears about this bill believes that already every attorney and client conversation should be privileged and is privileged. So it's not been a difficult sell at the legislature. It's just when the games began, just before sine die, when bills get stolen and moved and turned into vehicles, that it became a problem at all. So look for that one again next year. And in the meantime, if you have any loved ones who are in custody, warn them against even talking to their lawyers on any of the phone systems because their conversations are not currently privileged in any way, shape, or form. And then the other bill that we think is really good because it's Cackled bill that didn't pass is House Bill 1255. This is a discovery modernization bill. Um, it is not a very sexy topic to talk about how criminal cases are prosecuted, but the law that prescribes how evidence is exchanged between the prosecution and the defense is 40 years old. And as you might imagine, the evidence that's used to prosecute a case 40 years ago was a lot of paper, very little recordings, and even when they were audio cassettes. They weren't, volumes and volumes of electronic video and recorded phone calls or other voice recordings. We are now in a situation where lawyers are getting terabytes worth of data and expected to sort through it. And the timelines that are in place are simply untenable for that. Right now, the timelines are all tied to the trial. The prosecution's only required to provide that evidence 10 days from trial. And oftentimes 10 days is just not enough time to adequately review all that information. And that's just one example of how the discovery scheme is just antiquated. So our bill, we will try again. We collaborated with as many stakeholders as we could, including the sheriffs, the prosecutors, judges, even the clerks. And some of the key pushback is around cost. Some of that can be solved and some of it cannot. So at some point, the legislature is going to just have to make a call. The reality is that people who are being prosecuted have a right to see the evidence that is being used against them under our discovery. It's optional to opt into this discovery sharing, but once you do, you're going to get that information. So we are hoping that in time we can help find some ways to educate all the people involved about how the cost is already defrayed in the process, but also encourage some conversations about ways that costs can be minimized. For instance, maybe you don't bring trash cases against people that you don't ever really intend to take to trial because all of these rights, once they attach, whether or not the person ends up actually going to trial or taking a negotiated plea or the case being dismissed. So we'll see. Conversations will continue. We felt really successful with respect to how far we got in this session. This was the first time that we filed this bill. It was in response to a really terrible bill that the prosecution had filed to try to adjust discovery. And we even had people toward the end of the session saying to us, like judges and other actors in the system, wow, we had no idea you get this far with this idea. So we count the wins that we get, and that to us felt like a win. We've got the legislation to a place where a lot of the stakeholders were on board, including even the sheriffs. And so we feel like we'll be starting off the conversations that need to happen now from a good space, and you can look for this one to show up again in 2027. Now we're going to shift. This is you, Lake. I'll pass the mic.
All right. And now we'll move into discussion of some of the bad bills that unfortunately did pass. And I'm going to talk about one that uh, we've talked a lot about in the JRP for in 2025 session and 2026. It was House Bill 295. Um, and that bill uh, would allow property owners to sue local governments if they believe that the city or the county is not aggressively policing several offenses that are related to homelessness, a- and or the city or county is violating state law that bans sanctuary policies. Um, so the bill would allow property owners to sue the local government to recover compensation for any alleged decrease in their property value or to recoup costs or expenses that they've incurred uh, that they say is because the local government is not enforcing like low level quality of life crimes, even ordinances like bans on public camping or against loitering or panhandling. Um, and then also it was added on failing to comply with state laws regarding the enforcement of immigration law. So obviously we've been concerned about this. If you were ever able to attend any of the committee hearings, they were always packed with tons of great community leaders and organizations, uh, just repeatedly informing the committee members in the House and the Senate how terrible this policy would be. So the fear is that this will increase the pressure on cities and counties to just police homeless populations, um, shuffle them through the criminal legal system instead of actually providing real solutions like housing, mental health support, or developing or supporting or contracting with organizations like PAD and investing in community outreach and diversion. Um, because we know for decades and decades and decades that you can't police your way out of homelessness. So either those resources that should be directed towards that are being invested into policing, jail, court infrastructure uh, to handle homelessness that way, which doesn't work, or money that could be going towards these services will be going to of legal fees and litigation from just any property owner who's aggrieved that not enough homeless people are being locked up uh, can sue. And the way that the bill is structured is there's a lot of reason the deck is stacked very favorably for the property owner. So like we're talking about they will petition. If they lose, they just lose. If the local government is found that um their policy did cause this, um then they would have to pay the uh cost and attorney's fees. So it's like that one way hammer is only levered against the county there or the city. Um, Also, the burden is on the county or the city, uh, even though they are not the petitioner. So it can be very bad. the only sliver of hope is that so on Sunny Da, late, I guess early in the day, so or in the afternoon, like the Senate added a Senate amendment that would have also said any local governments that are violating the ban on sanctuary policies or are failing to honor and comply with immigration detainer requests. Both of those things are required under state law, recently passed during just the rash of anti-immigration legislation in Georgia and in other states. It would have waived sovereign immunity completely, which really would have very heavy-handedly disincentivized all counties and cities to protect themselves to just become incredibly harsh anti-immigration de facto extensions of Customs and Border Patrol and Immigration and Customs Enforcement. Just very nervous not to just say, yes, you tell me to jump, I ask how high. Luckily, on late in the evening, that was changed to where now anyone can petition for a court to tell the county or the city, hey, you're not following state law on the ban on sanctuary policies. So it could have been a lot worse in the immigration context. But as the JRP has followed for the past couple of years, aside from the immigration context, just the criminalization of poverty context, the bill is really, really bad. And that really, really bad version is what was passed. There are a lot of organizations who are still hopeful to stop this. So there is a call to action to urge the governor to veto the bill. GLAR, Project South, Housing Justice League, National Homelessness Law Center, and Project Community Connection Inc. Are kind of have organized that call to action. If you are in the resource handout that Anne has dropped in the chat, you can there's a link to a separate one pager for 295, which links to that call to action. And that said, I'm gonna pass it back to Maisie Lynn to talk about one or more other bad bills that unfortunately
Yeah,
passed.
unfortunately. So the bill passed as HB 369. It started out as SB 573, and I put that history there because interestingly, when it was Senate Bill 573, it failed on the Senate floor. But when it became House Bill 369, they agreed to very, very similar language. And what this does is it identifies basically urban areas like Atlanta, Gwinnett, so Fulton, Gwinnett, Cobb. It ties to whether or not there's an elected coroner, and that's just a real kind of sneaky way of carving out these more urban counties and saying that if you are one of these counties that no longer elects your coroner, then your district attorney and your sheriff elections are going to be nonpartisan, meaning no one can run as a Republican, no one can run as a Democrat. It's going to be more like a judicial election where no one has any kind of party affiliation. And on its face, that might sound kind of reasonable to most people in the sense that, well, really, why do we want them to be partisan? These roles, aren't they a little more like a judge in that sense? But this is the reason why they don't want it. In those areas, it is very difficult for someone to win those races with an R behind their name. These are heavily Democratic voting parts of our state that now will those candidates will not be identified by party. And so, but I believe the motivation behind the bill is a hope that they will be able to get more conservative voices elected to those positions as district attorneys and sheriffs in those counties.
Can I
Um,
add one other thing about
absolutely,
359?
please.
So the other thing is that this moves the election for these particular
Mm.
district attorneys to May instead of November when nonpartisan races are elected. And so that automatically makes it so that a lower percentage of the voters will actually come out to vote. And so it is a way to sort of depress voters, not depress the voters, the voting numbers that come in, and also sort of cause some confusion here for voters, right? Like you will have less information as a voter if you don't actually see party affiliation, and would have to do a little bit more work in order to make sure that you know who you're voting for.
Mm. Yeah, thanks for that. That's a great ad. I'm going to shift. We're getting, I know, close to the end of the hour, and I know we've got some questions out there. A couple of bad bills that are notable that didn't pass, and notable because we think that they are going to still come after these issues. The one that I'm going to mention to you is Senate Bill 468. This is a bill related to the Sex Offender Risk Review Board, or the group that we call SORB, that controls how people are leveled who are placed on the sex offender registry in Georgia. And this conversation didn't start with this bill. This is the bill. I've been at the Capitol now for just over a decade, and it has been a conversation for at least that long. And I'm sure it started before that because there are some parts of the Adam Walsh Act um, wherein states can access certain federal funding. And part of what in Georgia is considered to be out of compliance with respect to how it handles some of the aspects of its sexual offense registry. Um, and that lack of compliance means that Georgia doesn't get to access the federal funds that would be available if they were in full compliance. And um, the trouble is that to be in compliance with what the feds are wanting in order to access that money would actually mean that the way the registry is populated is not done on a case by case basis that really looks at all of the relevant factors that SORB is supposed to consider. And for instance, this bill would have just tied whether or not you were leveled as a level 2 or a sexually dangerous predator. They would tie those to the offense that someone was convicted of, which is not always the whole story. Um, and in fact, one of the most interesting things to me about the way this bill played out this year, and frankly has in the past, is that you have entities like Capital and Restore Georgia coming to the table and saying things that sound a lot like what SORB is saying about why the bill should not be passed. And frankly, anytime you have voices that are that disparate, typically coming with the same concerns, it really should be considered because it's really rare for us to have similar concerns about legislation like this. So we'll never know precisely why it failed this year, but I will hold hope that those kinds of unlikely ally conversations will continue to allow reason to come into these conversations around the registry, which can be so charged for people. They make decisions that will look good politically, even though they aren't rational or thoughtful. And so, if we can keep them thinking and making rational decisions, all the better.
So I will do these last ones relatively quickly because they are bad bills. They did not pass. I mostly want to talk about the overarching theme of these kind of bills because that theme isn't going away politically. So for example, SB 29 and SB 116 were two bills that would have pushed the state to continue expanding surveillance before conviction, right? This idea that like in it, like we are trying to show that we are going to keep track of people who are doing things we don't like. And even if they have not been convicted of a crime, we're going to take their DNA, we're going to keep it, and use it for any future actions or crimes that this person might commit. That is wholly unconstitutional. Let's just start at the beginning. But it reflects this familiar pattern of the state trying to widen its ability to collect and store very personal information, and lower that threshold for when that power can be used and for who. Because in this particular case, these two bills were targeting immigrants, and people who either were convicted of some sort of crime and have an ICE detainer, so they come up as a potential undocumented person in the DHS databases, or they are in an ICE detention center already. And so it is also fully redundant in some ways, like in some parts of the process, depending on what kind of immigration issue you might have, you might already have your DNA taken. And so it's a part of a broader theme and issue that I think we need to be very wary of, as the state continues to try to expand its ability to get and take information from us for things we have not actually done yet, right? That's a big problem. The second sort of set of bills that I wanted to talk about, are all the bills related to our First Amendment rights. Over the last few years, especially after George Floyd's murder, after the uprisings across the different states and cities, there was a big push, and it has continued to be a pretty steady push to, you know, take away your ability to access information, to curb your First Amendment rights, to punish your use of protest tactics, to chill speech, to restrict your civic participation, to criminalize your association. Like these are all the kinds of bills. There were 8 of them, not just a couple, 8 different bills in Georgia over the last 2 years that aimed at this particular issue of trying to get at your First Amendment rights. And there's all 8 of them are going to be in the handout that Anne will give out. But it's different. They're different vehicles, right? Like there are some that are about, we're going to say that this is about drag racing and you can't block a highway. And if you do and you block law enforcement, we're going to do a penalty. But you know who else blocks highways when something goes down? Protesters. And so there's a lot of ways in which they will find a pretext and say, oh, this is about protecting children. We're just going to criminalize librarians, though. And you're like, what? It is a very crazy kind of vehicle bills that they're using to kind of address these things that they don't like. They don't want you to access certain information. They don't want you to have certain conversations. And so they are trying to put in place a lot of threats to people in public, including the poor librarians that we had to organize to come to the Capitol several times, to say, the threat is enough for you not to shelve that book for those kids, not to put anything about families who look different than other people or kids who are different from other kids, because all of a sudden that's considered harmful to minors because some lady down the street is mad about it, right? Like that's not the same as like actually protecting children. And so all of these bills, there's a sort of through line here of a bigger issue that we need to be very well prepared to contend with as we continue because protests are not going away. Um, and these are all connected fights of just overcriminalization, censorship, surveillance, and anti-protest laws that are trying to get at your rights, trying to control your First Amendment rights, and prevent you from exercising them to the full extent of your ability, under the Constitution. And like I always say, the Constitution, so far, today, as of today, is not optional. So they cannot just go around doing this, but it would take a lot longer should they actually get to pass one of these nonsense bills for us to undo it. And so we do need to be very, very careful about these bills, and need to be very wary of them as we go forward. This is the last one that I'll talk about, is SB 617. And I think I talked about this at our last JRP meeting. This is a bill that attempts to take over municipalities, and put them under a receivership, which is usually used for like businesses who are like tanking, right? Or like under financial distress, puts them under this legal thing called a receivership and takes away that city's elected officials' ability to do anything with the city's finances. And so you are essentially saying to the people of that city who elected the people of your government to run your city, we no longer think you should be doing that. we are going to find some reason to say that you are distressed, and we're going to put this person over all of your finances, and then you won't have a city anymore after a while, right? Like they can like petition the attorney general and others to like say we're going to dissolve this entire city. And of course, where are they doing this? Quitman, Hiram, cities that are black led, have black leadership at the city council, at the mayor, and have a very high dense population in commercial areas, right? Who are like more likely workers of color, people who are working class, etc., right? And so they are trying to target these places where they can see political power bases growing that are not going to agree probably with some of what the majority is currently pushing at the state level, like criminalizing librarians. I cannot stress this enough. They try to go after librarians. And so we are trying to basically find ways to dissolve the power of those cities to self-govern. Like we're just going to take away your elected leadership. And that is a big problem. There were several cities that were about to lose their charter. The Georgia Municipal Association came up with this nonsense receivership thing. It's not good out here. We need people to be paying very close attention to these bills that look like they don't really do anything, except when you look very closely and you see them as the political tools that they are going to be used to get at political power in places where the state legislators don't actually agree with what's happening in those cities. So, for example, Hiram had said yes to a project around affordable housing, and they were essentially told, if you do this, we're going to come after your finances as a city, right? So like. If you have a city that is trying a progressive policy with the DA or is trying to figure out ways to like divert more people away from the jail or not wanting to just spend their entire, police time picking up people who may be experiencing homelessness or immigrants, those all of a sudden might be cities that these legislators think are distressed because there's something's going on that they don't like. And so they can then use these political tools available to them to dissolve them. And so, and if you have somebody who does not have the political will, they do not know this city very well, they can then turn around and say, you know what's going to make you undistressed? A new jail, a new prison, a new detention center. That's going to bring all kinds of jobs here, and then we won't be distressed anymore. That is not what the people of that city might actually want, but you are not letting the people of that city elect their leaders and have their leadership make decisions for them. And so it's very important that folks pay attention to these issues that are not necessarily like a new crime that we're creating or some like thing that we're trying to take away or a community that we're trying to hurt. All of those things are happening. Let me just be clear. But there are these other ways in which they are trying to go after political power in ways that are really insidious and really need to be like, we need to pay very close attention because this is not going away. This is going to keep happening. And we need to be prepared for those fights as we go into the next year. So those were my last ones. I don't know, Anne, if you wanna, I realize that we have run out of time. I apologize,
Yeah.
folks.
I don't think that, I think the questions that were in the chat were answered in the Q&A. If anybody has a last question, raise your hand or put it in the chat.
I did have one answer to the follow-up question of like, how do you know what's passed? So the official code of Georgia does get updated on July 1st. So anything that the governor did not affirmatively veto or sign that won't get a press release, you would be able to kind of see like what's new in there. It's not, they do not make it easy for you to find, right? But like you could technically find it. I will put some links as I find them in the chat for folks.
Okay. So Nikki, do you want to close us out before and if there's any questions, we'll pop back on, but otherwise I think we're good.
All right. Thank you all. I didn't see any hands up. So I wanted to give folks an opportunity if they did have questions.
Blake did have a good point, which is that on the trend of mass surveillance, they do have there's an obsession, and it's very true, with creating databases, registries, summaries, and reports for the legislature on a bunch of different things, right? And it's just another way for them to have more data at their fingertips to do bad things to whatever that registry is for, right? And so I think it's important for people to like be paying attention to those kind of bills as well. I don't have any off the top of my head, but that is a very good point.
And there is one last question if someone on the panel wants to answer it. Is there anything we can do about the bills that Governor Kemp is considering?
Yeah, if you my suggestion, and of course, like my panelists should speak up as well. You should be calling the governor. There's a way on his website to send him an email, make calls, call the folks in your, even if they are your state senators and representatives, they can also get them a message saying that you want this bill to be vetoed. Nothing is done yet until July 1st. We have some time. We should take advantage of it.
Hmm. And Blake put a specific call to action related to House Bill 295 up in the chat earlier.
Thank you. Thank you all. And just thank you, Anne, Maisie Lynn, Blake, Isabel. I don't know if Wade is still on the call, but you know, you all have been doing this since January, and it feels like it's probably forever, and you haven't had a break, and you're able to come on this call this evening and to just update us and give us great information. And I personally want to say thank you. And I know that our people who continue to support us appreciate you as well. So, one thing I would just want to close out with, take care of yourselves. I always say that. Take care. Yes, Isabel, go get some rest and a break, but take care of yourselves. Um, because we know we take a pause because January will be upon us again very shortly. Blake and I will be doing some work in the off season after we take a small break. So the work continues, but we have to take care of ourselves. Just a few things. I will share out the recording and the document that Anne provided for us for all the folks on the call and then all the folks that registered. We had quite a few people who registered because this work can't, end with us. It's about all of us together. So we have to share everything. There's no gatekeeping here. So all of our folks have shared some great information out. So we can't do it alone. We need you all to share all of that out with you, with your friends, your families, people in your community. With that being said, I'm going to put, or someone can put in the chat, our website, follow our website for upcoming Talk Justice Tuesdays. We don't have one scheduled for May yet. We will have one for June and July and throughout the rest of the year. That's how we stay engaged, y'all, and that's how we stay updated on what's happening. So that's all I have, and I really appreciate you all who have stayed with us. For some of these names have stayed throughout the whole session with us, and I just appreciate you because it's not easy coming on the calls at 12 noon or at 6 in the evening. So we really appreciate you. So with that, I'll say goodnight.